Hello guys, I warmly welcome all of you to yet another interesting and important segment of Indian Polity lecture series, and this time we will discuss on the relevance and application of Article 32 of the Indian Constitution, that is the importance of WRITS, constitutional remedies in India. So the entire lecture is based on only one article, that is the most important article of fundamental rights, that is Article 32. A right without remedy is meaningless, and Article 32 is that remedy which we will discuss today in this lecture series. Of all the fundamental rights, why is Article 32, the right to constitutional remedies, given a very, very special figure by the Constitution of India? If we search some reasons, there are certain reasons, of course, that makes Article 32 sovereign or superior to the other articles of fundamental rights. The first one is, let's remember, this is the guardian of all other fundamental rights. Article 32 is been declared as the guardian of all other fundamental rights. We has been given direct access to justice whenever our rights or justice are denied by the government or by private individuals. Instead of going to the high court and spending a lot of time, a lot of procedures, delayed procedures, or a lot of formalities, we can directly get the access to the Supreme Court, where the Supreme Court, whenever we submit to Supreme Court has a constitutional duty, not at discretion. Remember, if the rights are within the fundamental rights, Supreme Court will not hesitate to hear or hesitate to take up our case. Supreme Court has a moral duty or constitutional duty that they will come to our rescue. So that's the advantage of Article 32, and that's why Supreme Court will not, unlike High Court, if we choose High Court may not protect the fundamental rights, but Supreme Court, when you go make use of Article 32, let's be 100% guarantee that Supreme Court will come definitely to our rescue, because it is the guardian of all other fundamental rights. So these are the advantage, and these are the points that we should all the time remember. And the fourth is that making use of Article 32 protects democracy itself. So democracy means the happiness of the majority of the people. So when the rights of the majority of the people of that polity has been taken care of, then we can confidently say that polity's democracy is successful. So these are certain reasons, not exhaustive though. So these are certain reasons. That's why Article 32 has been given a very special figure by the Constitution of India. There are certain important features linked with Article 32. First important is, as per the Supreme Court's declaration, Article 32 is a basic feature of the Constitution of India. Therefore, Parliament cannot also take away the features, the powers which has been conferred by the Constitution on Article 32. Even through Constitutional Amendment Act, parliamentarians cannot. So this is why once it's a basic feature, it's very tough to change, to remove. So that is the first thing. Not even Parliament can make use of the power given by Article 368. The amending power cannot take away the features that is given by the Constitution under Article 32. Next important thing is that till now, the Constitution has conferred the right to protect people's rights, the power to protect people's rights in two courts, that is Supreme Court and the High Court. If there's a question as to can the lower courts also exercise power to protect people's rights, then the answer is right, is yes. And if there's another question as to who can empower lower courts to protect fundamental rights, then it is the Parliament of India. Parliament has the power, can empower any other courts as mentioned. That means any other courts which is below the Supreme Court and the High Court, subsidiary or subordinate courts, lower courts, Parliament can empower them also to protect people's, citizens' fundamental rights. So once that power has been given to the lower courts gets the mandate or authority or legitimacy to issue direction or orders or writs of any kind or all the kinds. That is what we should know. Not been mentioned as High Court, since already mentioned also before, that High Court is already enjoying the power under Article 226. So any subordinate court below the High Court can also get the power to protect people's fundamental rights. But that time, Parliament has to give, it should empower the rights to the lower courts. But that empowerment is not been done till today. That means what we need to understand is that till today, protection of fundamental rights is always done by the Supreme Court in the High Court only. That is the second thing. The third thing is that the right to move the Supreme Court shall not be suspended is mentioned. It's like permanent, never suspended, except there's a possibility that it can be suspended during national emergency when the country is faced with grave dangers or there's a war going on. And if the situation gets severe, then even Article 359 can be activated by the President of India. So remember, when Article 359 is activated, let's assume that the country is going on in a very a severe or extreme situation. So once Article 359 is activated, even the right to go to the Supreme Court to reinforce the rights of fundamental rights will not be available. So this is not automatic suspension, remember, but this is a notified suspension. When President will suspend even the right to go to the Supreme Court to enforce the rights by making use of, by activating Article 359. So when Article 359 comes in, Article 32 will go out. They cannot stay together. So it's like a very special feature, very sad also, that the countries, the citizens' right to go to the Supreme Court, at times when the situation gets very severe, it can also be suspended by the President of India. Now, jurisdiction of Supreme Court is original, but remember, not exclusive, because High Court also has been given similar rights or similar responsibility as mentioned earlier also through Article 226. So we just need to understand that citizens enjoys two options to enforce their rights. One is they can go to the High Court through Article 226, or they can directly move the Supreme Court under Article 32. That is the two choices that the citizens enjoy. Now, the next is the scope. The scope of Supreme Court is narrow, as mentioned here, because only fundamental rights. Let's remember all the time that Supreme Court cannot deal with other rights through in Article 32. So only fundamental rights can be entertained under Article 32 of Supreme Court. But High Court, the scope is wide, because High Court can deal fundamental rights and non-fundamental rights, although other rights is also mentioned. So other rights in the sense like it can be non-fundamental rights, it can be constitutional provided rights, or it can be statutory rights, those rights made by the parliamentarians, or it can be citizens' customary rights or customs and traditions rights. So any rights that affect social behavior of the citizens can be entertained under High Court's 226. So comparatively, the jurisdiction of High Court is wider than the jurisdiction of Supreme Court, as Supreme Court is narrow, which does not allow other rights to be entertained under Article 32. Let us remember this all the time. And but once applied, the coverage, the Supreme Court's territorial coverage is wider, as it can include entire India also. So I mean, the Supreme Court being the apex court of India, the jurisdiction can cover the entire India also. And another important thing that we need to keep in mind all the time is High Court may refuse to issue writs. This is very important. High Court may not, that's why High Court may not protect the citizens' fundamental rights and other rights, because 226 is not a fundamental rights. But Article 32 being the fundamental rights for the rights, we have a double protection here. Article 32 is a fundamental rights, and this is like, it's like right for the rights. Something we can just give that brief statement. So this being the fundamental rights, it's a right in itself. So Supreme Court cannot refuse. High Court might refuse to protect fundamental rights, but Supreme Court cannot refuse to protect the citizens' fundamental rights. Hence, Supreme Court is ultimately the defender and the guarantor of fundamental rights. Let's remember all the time. Now we have reached the core of Article 32. Article 32 provides 5 very crucial, very significant writs to the Indian citizens. And remember this, all the 5 writs are Latin, they have a Latin origin. They are all derived from Latin. First is habeas corpus, mandamus, prohibition, certiorari, and quo warrando. So we can explain this in my next slides. The first writ under Article 32 is the habeas corpus, which is a Latin word to have the body of. So the aim of this habeas corpus is to protect the basic rights to life and liberty. So there are certain cases where Article 32 can be activated. First, if the arrest or detention is illegal or arbitrary, but you can make use of Article 32. Now the next is detention. Any sort of detention is found to be not following legal procedure. Everything has to be legal, following a proper legal procedure, but if not, you can activate Article 32. Now, if detention, any sort of detention violates Article 14, 19, 21, and 22, these are not exhaustive, only some. So these are some reasons how you can activate Article 32. And this can also be included even private detention. Okay, if any private individual have detained another private individuals, even those cases can come under this one. Or legal orders issued by court to a person. This is another way of explaining article this habeas corpus. Legal order issued by court to a person or authority who has detained another person illegally. The key word for this habeas corpus is illegal, right? So if the arrest or detention is found to be illegal, then that itself is sufficient proof or sufficient reason to activate Article 32. Now the court is giving a legal order to produce the body to the court. So the court will decide the fate for the person, not the private individual, but the court. We have the court to discuss legally. So it's a court order to produce that person to the court so that the court will discuss the reason for the arrest or reason for the detention. To explain the reason for such detention, and if the detention is found to be illegal or not following any proper procedure, then the aim of this habeas corpus is to set free such detainee or such individuals from detention. So as mentioned again, both against the state and private citizens, action can also be involved. And the principle of locus standi does not apply and cannot apply also because the person concerned is already arrested or detained. So on behalf of that person, anybody, any third party can file a case or FIR on behalf of that concerned person. So locus standi cannot and does not apply here. Anybody can, on behalf of the person concerned, can file in the court or can give the information to any law enforcing agency. So habeas corpus cannot be applied to lawful detention, of course, to contempt of a legislature or a court, or detention by a competent authority. So any of this you can't file a habeas corpus on any of these 3 grounds. The second writs under the Article 32 is mandamus, which is another Latin word, stands for we command. So the term we stands for court. So let's understand it is an order issued by a court to public official or public body, not private. So asking him to perform his official duty, which is compulsory, which is mandatory that he should discharge, but otherwise he has failed or refused to perform. So this another word for mandamus is, it's like to all the neglected officials, government servants or public servants who have neglected their duties. It's like a wake-up call that they should start performing their duty, because no public job is sinecure. You are paid to the maximum for the discharge of certain official work for the progress of the country. So more of mandamus means more of accountability, more of transparency, efficiency in effectiveness and public administration and public governance. So these are a wake-up call to all the non-performing officers, not to private, but all the government officers, government workers who are either refusing or fail to perform certain important duties which otherwise it is supposed to be delivering or supposed to be performing. Mandamus cannot be issued against private or individuals, as mentioned earlier, or to enforce departmental instructions that does not possess statutory force. And the third one is, it also cannot be applied to any task or any power that has a discretionary rather than mandatory, or to entrust or to enforce a contractual obligation. Also, mandamus cannot be issued. And mandamus also again cannot be issued to any constitutional officers like President, Governor, Chief Justice of the High Court acting in judicial capacity. So these are not exhaustive, but these are certain areas that mandamus cannot be filed. But to be very precise, mandamus can be filed to any government servant who are not performing their duties, assigned duties, to wake up and start delivering, or to start doing its official work for the country, for the nation, for the state. The third writs available to Indian citizens under Article 32 is the writs of prohibition, which stands for to forbid. Now, what is prohibition? Higher court to a lower court or tribunals to prevent the latter from exceeding or usurping its jurisdiction. So the purpose here is to stop a court or an official body from hearing or from exercising certain jurisdiction, from taking up certain action. So the purpose is to stop that. Why? The reason is they don't have, either because that they don't have legal power to handle, or maybe it's beyond their own capacity or jurisdiction. So it's always issued. It's always a top-down order, that is always higher court to the lower court and not vice versa. So lower court cannot issue a declaration of prohibition to the higher court. It is always higher court to the lower court. So issued only against judicial and quasi-judicial authority also. So that is the fact that we should remember on this prohibition. How it differs from mandamus. Mandamus is you must do this. It's like compulsion. It's like compelling in public authority to take up certain action. It's like a push given to the public officers to start doing. Whereas prohibition is like it's stopping judicial action before it starts. Prevent action. It's like prevention. So prohibition is you must stop doing this, or mandamus means you must do this. So one is like activation into action, the other is stopping the process of action in certain issue and certain cases. Certiorari is the next writs, and which stands for to be certified or informed. Certiorari is a court order by which a higher court reviews the decision of a lower court or tribunals to determine if there is any legal error or not. So can be issued against judicial or quasi-judicial authority and administrative authorities also. How does it apply? The losing party files a petition for certiorari. So the losing party might file certiorari in the higher court if he sees that or feels that there are certain legal errors that have occurred while giving the judgment. The second important thing is that important question of law. If the case that is been considered is very highly important, then even it can be reviewed by higher court. Lower court have made conflicting decisions, so there's a conflict in the decision by the lower court. The higher court can always take up for review. And the fourth one is there a serious procedural error or injustice made to one party. So in all of these cases, certiorari can be applied and the litigant can get as far as maintainable justice. Now, key difference between prohibition and certiorari is that whereas in prohibition only preventive, prohibition is mostly preventive to prevent a judicial authority from starting certain action, but under certiorari it's both preventive and curative also, reviewing a decision already made. So it can be certiorari can be done after the action has been taken also, but prohibition is issued just before the starting of the action, so it can be more, it's a preventive, but here it can be both preventive and curative also. Finally, we have the last WRITS, quo warrando, which means by what authority or warrant. So courts, this is another court order that challenges a person's right to hold a public office or exercise a particular privilege or franchise. So challenges office holders, so there's a legality or eligibility can all come in here. So public office is very important for people's employment and for the survival of the society. So anybody cannot come in and take away this public office. There has to be proper qualification and eligibility has to be made in assuming public office. So quo warrando is on that capacity, it becomes very important. So questions whether someone has the legal authority or eligibility to hold a public office or position, or whether he has the qualification or eligibility to exercise the power that he is exercising now, or certain rights and privileges that of the public officers they are enjoying, whether he is eligible, whether he is legally competent or legally proper to exercise such rights and privileges or no. So the main purpose is to prevent illegal usurpation of public office is the primary hallmark of quo warrando, and removing someone who obtains office by fraud or any sort of illegality, fraud or kind of backdoor, not in a proper legal channel that he gets into the public office, then the court might dismiss such officers and stop somebody or someone continuing office after their term expires. There's a lot of cases also there, so even that can come under this quo warrando, and the writ can be issued only in case of a permanent public office, not issued in case of ministerial office or private office. So two things can be kept outside this quo warrando, that is private office and ministerial office, and all of those bureaucrats or public office can come in under this quo warrando.